Hello, everyone. I'm Stephanie Rickard. I head up the procurement team at VWV, and I'll be presenting today's webinar. Thank you very much for joining. Before we start the webinar, I have a short message from our events team. If you have any technical issues today, please check your Zoom settings in the Zoom banner or leave a message in the chat box below. Alternatively, try disconnecting and rejoining the session. If you have any questions throughout today's webinar, please pop them in the Q&A box and not the chat box, please. Any questions in the chat box may be missed. I'll aim to answer as many questions as possible, time permitting. This webinar is being recorded, and we will aim to send you a copy of the slides along with the recording in the next few days. So we're now going to start the session. It's great to see so many attendees from all over the UK. I think we've got attendees from England, Wales, and Scotland, and representatives from universities who are both inside the Procurement Act, but also universities who have declared they're outside the procurement rules. Next slide, please. The objectives of this session are to update you on recent developments since the Act came into force. I'm not quite sure whether it seems a short or a long time since it came into force. And I know we were all waiting for so long for it actually to come into force. I'm also going to provide some insights, both from my private practice experience of how the Act is operating in practice, but also from speaking to a number of HE practitioners. Going to talk about some specific issues for the AHE sector. And then looking forward, I thought it would be useful just to focus on contract management and contract modifications now that everybody's entering into contracts under the Act. Next slide, please. So I think my heart slightly sank when I saw the proposal on growing British industry jobs and skills amendments to the Procurement Act. I want to discuss that in a bit more detail, and I'll come back to this. But one of the significant reforms under the Procurement Act was the introduction of the debarment list. So clearly there is a lot of interest around how this is going to work, and the first unlucky suppliers to be put on that list. Now, I checked a couple of days ago, and the debarment list is still empty. But there have been a couple of developments in this area. So, and they all arise out of suppliers who were criticised in the Grenfell Tower inquiry. Now, one of those suppliers was actually excluded from the Royal Borough of Kensington and Chelsea from future tenders, but it raised a JR challenge earlier in the year against that decision to exclude it. And the supplier in question was a manufacturer of external passive fire protection, but there was no evidence that it had contributed or its products had contributed to the fire. And in fact, it had been helping with the inquiry. So it was successful in having its exclusion lifted. But there were 7 other Grenfell suppliers, against whom the Cabinet Office decided to start an investigation into debarment. And as you know, it's not an automatic decision. A minister has to propose debarment, and then there's an investigation. And then, if a decision is made in principle to debar a supplier, there's a right of appeal. So the Cabinet Office started that procedure, but it announced in July that because of ongoing criminal investigations, it was going to pause the uh, debarment process because they were concerned about prejudicing the criminal proceedings. Now, if the criminal proceedings go ahead, and the suppliers are found to have committed offences, then the department might come back again. I've had a look at the procurement policy notes, both for England and for Wales, and there have been a lot of policy notes that have been issued, but they may need to refresh uh, the policy notes to make sure that they are compliant with the new Procurement Act. There have been a few new ones, but they're mainly addressed to central government rather than the wider public sector. For example, there was a PPN which advised central government to carry out spot checks in large public sector contracts to check that their suppliers were adhering to payment terms. Um, I think that's relevant because what's happening with the consultation is that some of the uh, procurement policy notes that apply to the central government are proposed to now be extended to apply to the wider public sector. So if I can move on to the next slide and provide a bit more detail of the changes. So by way of background, the consultation on reform comes out of really the National Procurement Policy Statement. So you'll recall that the policy statement or the act was delayed to allow the Labour government to introduce a new um, PPS, which was introduced just before the act came into force. But it's now the proposals come out of that National Procurement Policy Statement, and they're aimed to improve domestic competitiveness and uh, the and to support British business. And so, what the consultation is about is extending the obligations for central government to uh, to the wider public sector, which would include universities, so that you have a mandatory 10% social award criteria, that there is a right to exclude contractors for late payment. For those contracts over 5 million where you have to have KPIs, that at least one of those should be in relation to suppliers' contribution to jobs or skills, and also for large value contracts for the procurement teams to carry out a make or buy assessment before deciding to outsource a contract. So there's a number of concerns that have been raised about the consultation, again in terms of the admin that is more admin that is being placed on the wider public sector, but particularly in relation to the social award criteria, that social award criteria covers jobs and skills, but it also covers things like sustainable and responsible procurement and well-being, and therefore there's too much emphasis on just jobs and skills. We don't know if the following the consultation, an amendment will be made, but a statement was made in Parliament that it'll be when parliamentary time allows. So that suggests that it's probably going to be a while in the future. The other point that I just wanted to mention, which has come out in the last couple of days, is that the Procurement Review Unit have just published their report on investigations that they've carried out in the last year, I think up until July 25. It's quite interesting because it provides a list of all the complaints, the nature of the complaint, and what action was taken. There are not too many universities on that list. There's quite a few universities where they're in relation to the university hospital trusts. Interestingly, the themes that come out of the report are complaints about uh, how the evaluation was carried out or about payment. So I'm going to move on to the next section of this talk, which is about how the Procurement Act is operating in practice. I'd be very grateful if you could, we've got some polls coming up on the next page, if you just answer a couple of questions. So, have you issued or are you planning to issue a competitive flexible tender under the Procurement Act? And also, what has been your experience with either the central digital platform or, for those of you in Wales, the Welsh digital platform? I'd be very interested to see your answers. Okay. All right. So, in relation to the first question, it's about, gosh, it's pretty evenly split, about with only 33% or 30% saying that you're planning to issue a competitive flexible tender. I think my observations is that people want to make sure that they're comfortable with the Procurement Act before issuing a competitive flexible tender, and therefore there's quite a lot of caution around that. I'm going to talk about some facts and figures from Find a Tender, and I think there don't seem to be too many competitive flexible procedures that have been issued. And in relation to the second question, if we could go on to that. Right, that doesn't seem to be working. But I mean, my experience of an essential to digital platform up until fairly recently has been every time I try to access it, it crashes. Um, Although I did have some uh, success more recently. Okay, right. So moving on to my insights in terms of the Act. Uh, as I mentioned in previous webinars on the Procurement Act, the way that the Procurement Act or the procurement new procurement rules have come into force is you've got a framework. So you've got the Procurement Act, which is the framework, and then you've got the Procurement Act regulations or the Welsh regulations that sit below it, and then you've got sort of non-binding guidance notes. And because of the way that it's been designed, I found that in practice, when you're working through issues, there are some gaps in the legislative framework. And a good example of that is I was looking into central purchasing bodies and the roles, and the position on liability has changed slightly under the Procurement Act. But I went round in circles in trying to understand the new position. There's no actual definition of a central purchasing body in the Act, so that's quite tricky in trying to give definitive advice. So to date, my view is it's a mixed bag. Certainly, there's greater flexibility uh, to be taken advantage of. Uh, I know clients are finding the parallel system can be confusing. So we've obviously got the dual regimes for the moment, and I suspect it's going to carry on for a couple of years of the Act being in force for procurement started after um, 24th February, but before then, or for call off under frameworks, you've got the uh, old rules under the public contracts regulations. For those of you who are uh, also dealing with universities and university hospitals, you may also be coming across the provider selection regime. And of course, in Wales, you've got slightly different rules for devolved procurement. Everything is taking a bit longer because of the need to make sure that it's the first time of doing things, you're doing it absolutely right. Clients are cautious, and the overwhelming uh, feedback that I'm getting is that procurement teams who are already tight for resources are struggling with the burden of transparency and contract management. On the next slide, I've got some, well, I've called them HE facts and figures. These were taken, I did some checking on Find a Tender, and these were checking from the 24th of February up until the 29th of August. And I do find it a bit difficult to check on Find a Tender, but from what I could find, I found 262 pipeline notices, and of course, um, pipeline notices, there may be more than one for one from university if you've got large value contracts that are coming up for advertisement in the next year. Uh, a total of 461 tender notices, and about half of that again are transparency notices, and I think that probably is consistent with the fact that universities obviously procure a wide range of goods and services, and sometimes there's only one party that is able to supply that, and so I expected to see a high proportion of transparency notices, although perhaps um, not the one where there was a transparency notice to appoint a co-op franchise on site, which I found slightly surprising. uh, Probably I thought the number of tender notices would be higher over that period. So I only found 10 competitive flexible tender notices, which is pretty low. Maybe that there are more coming through. And a point that will come out through some of the slides later is that there were only 7 uh, notices to establish a dynamic market, and that wasn't, so the figures above are just HE specific, but the 7 notices are all across the wide public sector, which is very low. And I think the dynamic market um, has not been very successful for reasons that I go on to talk about. So on the next couple of slides, I've chosen a couple of areas which I've come across, and that's sort of my insights on sort of things that have gone well and things that have not gone so well. So one of the things that I think has gone really well is the procurement specific questionnaire. Now I understand that some of you may have been involved actually in providing feedback on the procurement specific questionnaire, and I think that probably um, comes through in that actually I'm finding it a really useful document, and I'm advising contracting authorities, although it's non-mandatory to use it. I think it's a much better document than the old standard selection questionnaire, which was very rigid. So I think it's good because it's helpful to remind suppliers to register and submit and share code supplier information and information regarding associated persons. It asks for information about intended subcontractors so that you as contracting authorities can check all the interested parties against the debarment list and consider exclusions. But there's much greater flexibility to assess suppliers' conditions of participation. So you've got much greater freedom to set out information about minimum technical experience or standards. I've just put a note there about it's a general note about make sure if you are including minimum standards that you set out very clearly what the pass-fail line is and how you're going to assess that. So on the next slide, I've mentioned, or I've done a quick comparison of framework and dynamic markets because this was something that sort of I was quite surprised about in terms of the original intention with the reforms was to open up dynamic markets to a wider range of uh, services and supplies. But I think that actually the new dynamic market is much more restrictive. So both the open framework and the dynamic markets have the advantage of allowing the onboarding of new suppliers during their terms. Obviously, with a closed framework, you can't do that. So under an open framework, the framework has to be opened up at least twice during a 8-year maximum term. And I suppose the question I've got is how is it going to open up in practice, and will it actually save time as opposed to having a 4-year framework and then starting a new framework? One of the restrictions about an open framework is that you can only keep it going if there are no changes during the term. But I think that open frameworks are going to be much more popular and probably take the place of dynamic markets because of the way that dynamic markets have been structured. So they're not the same as a dynamic purchasing system. And the main reason is that uh, under the dynamic purchasing system, once you had set it up, it was very easy to have a call off under the dynamic purchase system. You uh, invited all the qualified suppliers to participate, uh, which but the issue with the way that the dynamic markets has been structured under the Procurement Act is that every time you want to call off under the dynamic market, you have to issue a tender notice for each award and then wait a certain amount of time to allow new suppliers to get onboarded. So I just think it adds extra time into the process and doesn't allow flexibility. It's also been clear that it's not available for below threshold uh, awards. So I'd be very interested in other people's experience of dynamic markets. Again, I think the fact that there are only 7 across the whole um, public sector indicates that it's probably not going to be used except for utilities. Right. So my next slide is on assessment summaries. And as mentioned in previous webinars, the new assessment summaries are a potential area of risk. The idea is that the new assessment summaries are supposed to make it quicker and easier to provide feedback to unsuccessful suppliers um, rather than the standstill letter. But I think to the unwary, the risk is that you're providing more detailed feedback to unsuccessful bidders, and any discrepancies against the evaluation matrix will become apparent. So just some reminders that uh, assessment summaries need to be sent to both successful and unsuccessful bidders prior to the contract award notice, but it's the contract award notice that marks the start of the standstill period, not the provision of the assessment summaries. Uh, as well as getting their own assessment summary, the unsuccessful bidder will get the assessment summary for the successful bidder, but redacted where there's confidential information. One of the reasons why I think it it's going to take quite a lot of time to do this is that it's very clear uh, in the guidance and the Act that the assessment summary contents must refer back to the content of the submission. So if you just said, or somebody's going to score a 3 and its response was acceptable, that's not going to be acceptable from an assessment summary point of view because you need to pull out the information from the tender response to say uh, what was missing to make it score higher, um, or why it only scored a 3. And so my advice is, or practical tips, is really to consider uh, what the information that needs to be provided in the assessment summary when designing questions, and to make sure that evaluators and moderators have training on completing the uh, evaluation matrix, because very often it's going to be that form, well, it will be that form that is then provided by way of assessment summaries, and what to include and what to be very careful about including. And it may be useful for high value, very important contracts to carry out an audit internally to make sure that the assessment summaries um, are appropriate. It's also really important to think about confidentiality of successful bidders and how you're going to redact the information in their assessment summaries, and obviously that takes time. If you want further guidance on this, we have prepared a VWV guidance pack on providing assessment summaries, which provides a lot of details on do's and don'ts, and it provides sample um, assessment summaries and advice on the contents. And it has a lot more information than the template guidance that is available on the pathway. So just looking at particular issues from an HE perspective, I mean, one of the trends that we're seeing across this sector is the number of universities uh, declaring that they are no longer contracting authorities and therefore outside of the Procurement Act, on the basis that your income from private sector accounts for more than 50% of total income. I'm not sure whether that was an unintended consequence of uh, the Procurement Act, but you can see that coming out of the Act provides greater flexibility and reduces the significant administrative burden that's now being placed on procurement teams who are required to comply with the Procurement Act. But a couple of things to just to mention is that it's really important for universities that have decided they're not contracting authorities to carry out an annual review, because obviously the income changes year on year. And we have had clients who have decided that they're no longer contracting authorities in one year, but in subsequent years have received capital funding or funding from government, which has meant they've flipped back in. And actually, that is quite tricky in terms of making sure then for the procurements for the forthcoming year that that they are compliant, but also in terms of communicating with suppliers about uh, the changes. And obviously, whilst universities may be outside the Procurement Act, they've still got to have regard to the need to comply with charitable obligations and ensure that assets are used to deliver best value. And there are pros and cons of coming or being inside or outside of the Procurement Act, both in terms of opportunities for government funding and a wide range of issues. But of course, universities, where they are receiving government funding, got to comply with the procurement rules, may still want to carry out uh, procurement processes on a voluntary basis in accordance with the Procurement Act, and therefore it's important to keep up to date with developments. On the next slide, I've mentioned um, this, but the learning and work to get ready for the Act has been overwhelming at times for some teams, and I'm aware that there have been teething issues with the central digital platform, been issue with getting share codes, that not all notices are available. I think that was made clear by Cabinet Office, but what perhaps has not been so apparent is that some notices, once you're putting through the system, you can't go back and edit them once the information has been populated. So that's a time-consuming process. You make a mistake, then you've got to start all over again. But I think an expected consequence of the increased transparency for universities um, is that where you have got direct awards, or you're considering um, contract changes, or you've got a very large contract which needs to be published, there's going to be enhanced scrutiny, and therefore that's a good thing, but it also means that needs to be uh, taken into account in terms of your procurement processes and governance. All right, so in terms of, I'm now moving on to the sort of third section of the webinar, which is a look forward. Now that you will have got contracts that have been procured under the Procurement Act, look forward at contract management and contract modification, because it will become more relevant. And contract management, this is just a reminder of the new requirements. So there's an obligation to publish contract information for awards over £5 million. There is an obligation to issue contract performance notices in relation to suppliers' compliance with KPIs, again for large value contracts. And if there's an issue with performance against the KPIs, that needs to be carefully considered, because that could be a ground for exclusion under the Act. And we anticipate this is going to be a tricky area, and may need specialist legal support. Mention also the requirement to issue contract change notices, certain circumstances, and contract termination notices, and the requirement to carry out continued monitoring of suppliers throughout the contract for conflict of interest, and in case a supplier substitutely becomes an excluded or excludable supplier, or on the debarment list. So, as mentioned earlier, transparency means, in terms of the requirement to publish contract change notices, means that there'll be to be greater scrutiny of contract modifications. And like many changes under the Procurement Act, there have been changes to contract modification, and they're quite subtle, the changes, but the rules are quite complicated. I'm going to try and provide a summary of the rules. So contract changes are only permitted in four circumstances: where you've got a light touch contract, for example, for educational services, where the change is permitted under Schedule 8 of the Procurement Act, where the change is not substantial or the change is below threshold. Now, it's part of the complication is the way that Regulation 74 has been set out. So you're dealing with quite a lot of double negatives, which is try difficult to get your head around. Uh, but on the next slide, I'll try and explain uh, some of these. So uh, you do have to publish a contract change notice if you are dealing with a permitted change under Schedule 8. But if you are dealing with changes which are either to light touch contracts or to below threshold modifications or to non-substantial modifications, you don't have to um, issue a contract change notice. That sounds really good, but in practice, the thresholds are quite low. Now, the easiest way to explain this is that uh, below threshold modifications deal with modifications which have a monetary implication, and non-substantial modifications deal with changes which have a change to the term. So if you have got a below threshold modification, and some of the language of this will be similar to you from Regulation 72 under the old public contracts regulations, if the change is able to be monetarized and the value of the contract goes up or down by less than 10% for goods or services or 15% for works, uh, and provided it's less than the threshold for the type of contract. So if you're looking at services, that is the value of the change less than 21.5K, you might be able to take advantage of the below threshold modification. But that's a fairly low threshold, as you can see. The other conditions are there must be no material change in scope, and you can have uh, successive changes, but it's limited uh, by the fact that each successive um, change must be no more than 21.5 for goods and services. If you look at the non-substantial modification, uh, then this looks at changes to term. And so you've got a figure of if you have got again an extension in the term, possibly a reduction in the term as well, but in most cases that we're asked to advise for, it's always clients wanting to get an extension of the term, that it can be no more than 10%. Now, if you're looking at a term of 4 years, that means that you can't have any more than a 4-month extension, if I've done my maths correctly. So um, we often get asked by clients if you can have an extension because actually the contract's going to terminate, and it takes quite a lot of time to carry out a procurement process, and therefore it's often need to have an extension. But 4 months isn't going to be very long extension in the scheme of things. And you also have to have no change in scope and no change in economic uh, interest. So, as mentioned, there is some flexibility, but there's a complicated hierarchy of rules, and the thresholds are quite low. So, on the next slide, I've set out some of the circumstances which are permitted under Schedule 8. And as mentioned, these require a contract change notice. So some of these will be familiar. So a change expressly provided for in the contract in clear and unambiguous terms, unforeseeable circumstances. The main new change is if you have the materialization of a known risk, but that needs to have been identified in the tender documentation up front. But I think this is actually a um, an improvement because, for example, um, if you have got an IT contract that you're looking to procure, and you know when you're going out to tender that there's a possibility of a known risk, for example, in terms of software upgrades, or you're not quite sure whether it will cover um, certain aspects, you can provide you need to highlight it in your tender documentation, but it's essentially the same as allocating risk as if you would for a change of law which may come into force. And it allows you to uh, trigger a contract, a permitted contract modification. One of the other things that I just wanted to mention on contract modification is that there are special rules for convertible contracts, and those are contracts which, when they went out to tender, weren't required to be advertised, but because of increase in scope or term, um, then become required to be advertised, and they're called convertible contracts, and special rules for call-offs under framework. So it is quite complicated and difficult to get your head round. On the next slide, I put out some ideas in terms of how to help manage risk. And the first one, really, which is when you're carrying out a procurement of a large contract, you're probably going to be carrying out a risk register and identifying risks and likelihoods of risks as part of your business uh, plan. And that can be a really good opportunity to think about known and unknown risks, and try and include those early on so that you can take advantage of permitted risks later on. And there is the possibility for minor changes, but be very wary of the thresholds. Okay, so I thought we've done a sort of a look back, a bit look forward, and this section is sort of further look forward. So I think the questions that everybody are going to be interested to see is when are we going to get our first procurement cases? At the moment, I'm not aware of any cases that are going through uh, the courts. Has anybody's got any other information of that? I'd be very interested to hear about that. And we're expecting to see the first challenges to be in relation to exclusion or debarment, and how, if proceedings are brought within the very tight standstill period, how the courts will deal with the decision to lift the automatic suspension. I've put use of AI in procurement because I think that is going to be a topic that we're going to see more of in the coming years, and to see how that's going to develop. So just in terms of key takeaways, some reflections on the first 6 months. I think there are flexibilities to be taken advantage of under the Procurement Act. It's a question of being brave and try and take advantage of them. But when considering procurements, plan for increased preparation time until the rules become more familiar. And as I always say on my webinars, please don't forget to keep an audit trail. just a plug, if you're interested in subsidy control, that there'll be a subsidy control webinar, particularly focused on HE issues uh, in December. So please keep a lookout in your invites for that session. I think there have been some questions in the inbox, so I'm just going to go and have a look at those now. But uh, also, if you don't have any particular questions, but I'd welcome any comments you have on how the Act is working from your perspective. Okay, so interesting question here. What is your view that the UK government has apparently said that they will financially not bail out any university? Therefore, that seems to confirm that we are not a public sector body. Well, I suppose anecdotally, I know that there has been an example in Scotland where one of the universities has been given a loan by the Scottish government, but as you say, the UK government has said that certainly in relation to England, they're not going to financially bail out any university. I suppose it's a slightly different question because whether you're a public sector body has a specific meaning under the procurement rules, but also it has implications under data protection and also under sort of public sector equality. So, and the tests are different for different legal uh, tests. So I would just make that point. So I think they are connected, but they're not quite uh, connected. I hope that's answered that question. I'm just looking to see if any more have come through. I don't think there are any more questions. So we'll leave it there. Thank you very much for attending. If you have got any questions or comments that you want to make offline, please don't hesitate to contact me at my email address. Thank you.